What if entire spiritual systems could be erased with the stroke of a law? What follows is a clear, uninterrupted narration exploring 25 faiths, movements, and practices that at various times were declared illegal, suppressed, or criminalized by states and authorities. This is not a judgment on belief itself, only an examination of the reasons governments have moved to outlaw certain expressions of the sacred. Listen closely. This single continuous voice will carry you through history, law, and the uneasy meeting of conscience and power. We begin with a movement that grew into a phenomenon too large for one government to ignore. Falun Gong combines slow-moving exercises, meditative practice, and moral teaching into a social current that attracted tens of millions. Its growth outside official party channels triggered alarm and ultimately a harsh national ban. The lesson: numbers can turn spirituality into a political threat. Next, we look at syncretic Afro-Caribbean traditions born of displacement and resistance. Practices that blended African cosmology, indigenous rites, and Christian forms were frequently branded by colonial authorities as dangerous superstition. In many cases, bans were enacted because officials feared these rituals could organize people outside colonial control. Religious practice became shorthand for rebellion. When churches answer to institutions based across borders, wartime governments may treat them as security liabilities. Branches tied to foreign patriarchs or external hierarchies can become suspected conduits for influence or propaganda. During conflicts, states sometimes restrict or dissolve these branches under national security rationales. Ecstatic and unregistered worship gatherings have repeatedly run afoul of regimes insisting all religion be funneled through approved, state-supervised bodies. Loud revivalist services, open-air shoutings, and unauthorized assemblies are sometimes framed as public order problems and shut down. The tension here is simple: centralized authority versus the unpredictable energy of grassroots devotion. Movements that proclaim new revelations or prophets often provoke harsh responses. When a leader claims new divine authority, established religious institutions and the state may view that claim as both doctrinal heresy and political destabilization. Governments that equate religious uniformity with social stability will outlaw such reformist sects rather than tolerate doctrinal competition. Accusations of witchcraft reveal another pattern. Long after legal reforms elsewhere, some legal systems still criminalize alleged sorcery, sometimes leading to arrests, trials, and violent punishments. These measures are typically justified by public safety concerns, moral panic, or the desire to control marginalized healers who operate outside formal medical systems. New religious movements that assert novel succession or divine claims face particular peril under theocratic regimes. Where a faith's legitimacy is tightly policed, deviation becomes a criminal matter. Leaders who position themselves as successors to canonical prophets often find themselves on the wrong side of blasphemy laws. Apocalyptic communes led by charismatic figures can morph into dangerous enclaves. When isolation, child rearing under strict control, and psychological manipulation come to light, states may intervene. Prosecutors face difficult thresholds. At what point does spiritual devotion cross into abuse and criminality? Siege events and tragedies have sharpened legal responses. Mystical schools promising direct, individualized encounters with the divine sometimes circumvent clergy and institutionalized intermediaries. In hierarchical states that rely on established religious structures, such independent channels of spiritual authority are often seen as threats and may be curtailed. Charismatic leaders demanding absolute obedience can convert faith into exploitation. When financial coercion, sexual abuse, or forced labor are revealed, authorities charge leaders with criminal offenses. Spiritual language complicates prosecution, but the law typically acts when harm is provable and victims seek redress. Ultra-Orthodox splinter groups who reject civic registration or modern amenities occasionally run into legal prohibitions, especially when their practices affect children's education, public health, or participation in civic life. The state balances religious liberty with obligations to protect minors and uphold basic social order. Criminal bands cloaked as ritual cults, groups that ritualize theft, murder, or kidnapping, have always been treated as criminal conspiracies rather than legitimate faiths. Where belief serves as a rationale for violence, Outlawing the organization is both a criminal and a moral response. Millenarian movements that use theology as a political program have triggered violent suppression. When charismatic leaders mobilize followers toward insurrection under spiritual pretenses, governments respond with military force. The combination of religious zeal and political ambition is particularly combustible. Armageddonist compounds have produced some of the most dramatic legal confrontations. When weapons are stockpiled and children are isolated, the state's duty to prevent harm can justify preemptive action. The stakes are always high. Prosecuting beliefs risks persecution, while ignoring clear signs of abuse risks tragedy. Religions that fuse racial supremacism with sacred rhetoric are commonly prescribed where laws criminalize hate speech and incitement. When theology is used as a vector for violence targeting groups, countries move to ban organizations and prosecute leaders under anti-terrorism and hate crime statutes. Occult nationalist cells that blend extremist ideology with ritual practices are also on the radar of security services. Their secrecy and violent orientation prompt bans and surveillance, as intelligence agencies prioritize public safety over neutral tolerance of eccentric belief. Syncretic reformers who defy clerical power by composing new scripture or combining traditions often invite strict responses in places where the established clergy is politically entwined with the state. Dissenting spiritual literatures become illicit when orthodoxy and sovereignty are joined at the hip. Rituals causing bodily harm, whether from self-mutilation, coerced surgeries, or practices endangering children, are frequently outlawed on the grounds of bodily integrity and public health. Liberty has limits where clear, non-consensual harm is involved, especially to minors or those unable to consent. Radical ascetic sects that neglect members' basic needs sometimes force legal intervention. States prioritize welfare and public safety. When ascetic discipline leads to malnutrition, preventable disease, or death, authorities act to protect vulnerable adherents. Secret societies that use oaths and ritual to advance political violence are treated as gangs. The law distinguishes between private belief and organized criminality. When rituals become recruitment tools for violence, prosecution follows. Nationalist cults that twist myth into mobilization for ethnic violence face bans. When spiritual narratives are weaponized to exclude, target, or purge, states often respond with prescription aimed at preventing mass harm. Fraudulent messiahs who exploit followers financially are prosecuted for fraud, embezzlement, and abuse. Spiritual promises that become commercial coercion are not protected simply because they use religious language. Courts apply fraud statutes where deception is proven. State-defined heresies remain a reality where the law itself defines orthodoxy. Apostasy or conversion in some nations carries severe penalties. In these jurisdictions, the protection of the sanctioned faith justifies criminal penalties for divergent belief. Terrorist cults that sanctify violence are universally prescribed. Any movement that endorses murder, terror, or mass violence under religious pretexts is treated primarily as a security threat and prosecuted accordingly. There is no protected status for violent conquest dressed as salvation. Coercive totalist movements that isolate and dominate members present the most acute legal and moral dilemmas. When the spiritual leader controls every aspect of life, marriage, work, movement, access to information, the state often intervenes to restore autonomy. Law and human rights frameworks converge in efforts to dismantle systems of total domination. Across these 25 categories, patterns emerge. States outlaw practices when they threaten order, public safety, or the interests of dominant institutions, when they inflict clear harm, or when they become centers of political power outside the state's control. Sometimes the reasons are legitimate protective impulses. Sometimes suppression reflects authoritarian intolerance or cultural imperialism. Legal responses vary: criminal statutes, administrative dissolution, registration requirements, bans on public assembly, restrictions on proselytism, and in extreme cases, capital punishment. The same legal tool can protect citizens or punish dissent. Which it becomes depends on the integrity of institutions, the rule of law, and the presence of independent courts. Ethically, outlawing belief presses hard against human rights norms. Freedom of thought and religion are foundational in many international instruments, yet states routinely carve exceptions in the name of security, public morals, or health. The challenge is distinguishing genuine protective measures from repressive acts that silence minority faiths. For victims, the consequences are immediate: loss of worship spaces, harassment, imprisonment, and social ostracism. For societies, the costs include diminished pluralism, the entrenchment of fear, and the potential for cycles of radicalization. When states crush a movement without addressing underlying grievances, the belief may retreat underground and resurface in more dangerous forms. As listeners, we must weigh complex trade-offs. Absolute religious freedom without limits could permit harm. Absolute prohibition risks tyranny. The middle path requires transparent legal standards, independent adjudication, and remedies that prioritize protection without sweeping stigmatization. Consider concrete historical dynamics that voice actors can render smoothly. Colonial governments outlawed indigenous ceremonial life not solely over doctrine but because those ceremonies enabled community cohesion and, potentially, rebellion. Enslaved people's spiritual traditions were criminalized to weaken mutual aid networks and limit the organization of resistance. In other eras, authoritarian regimes banned meditation groups or grassroots movements that organized outside state structures because those groups created parallel sources of loyalty and trust. In modern democratic systems, bans more often reflect a response to demonstrable harm, child abuse, financial exploitation, or violence. Yet even democracies struggle to calibrate the line between protected religious exercise and criminal conduct. The law uses tests: harm to others, coercion, deception, and public safety risks. But enforcement is uneven, and marginalized faiths often bear the brunt of suspicion. Legal frameworks sometimes create perverse incentives. When a state criminalizes a practice without offering a safe avenue for dissent, adherents either abandon faith practices or shift underground, where risk multiplies. Transparent oversight, witness protections, and dispute resolution mechanisms reduce these harms. Human rights bodies recommend narrow, proportionate restrictions tied to compelling state interests rather than broad, vague prohibitions that enable discrimination. For practitioners, the lived experience of a banned faith is harsh. Worship becomes furtive, leaders may be jailed, families are stigmatized. For scholars, the study of prescribed religions reveals patterns of power, fear, and cultural domination. For policymakers, the task is fraught: protect citizens while safeguarding conscience. The solution requires humility, legal clarity, and ongoing review. This continuous narration aimed to be clear, uninterrupted, and suitable for AI voiceover. It surveyed types of faiths and movements that states have prescribed, explained the rationales often invoked, highlighted the legal tools used, and reflected on the ethical tensions involved. Whatever your perspective, the history of banned religions is a mirror. It shows what societies fear, what power protects, and what freedoms are precarious. If this long, single-voice explanation sparked questions, consider which cases merit greater sympathy, which require stricter regulation, and how a society should balance liberty and safety. In practical terms, advocates and lawmakers should press for narrow legal definitions, independent review, protections for victims, and remedies that permit peaceful practice while preventing harm. Courts must remain vigilant against laws that masquerade as neutral but have discriminatory effects. Civil society can help by documenting abuses, supporting affected communities, and promoting dialogue across faiths to reduce misunderstandings that often lead to repression. The consequences of getting this balance wrong are severe: persecution on one side, unchecked harm on the other. Think about recent examples where banning a practice only deepened resentment, and contrast them with cases where careful regulation resolved abuse while preserving peaceful worship. The goal of law should be to reduce suffering and uphold dignity, not to extinguish belief. Thank you for following this uninterrupted narration. If you'd like a version broken into chapters or tailored to a specific narration speed, I can produce a timed version next. Think critically, protect safety, preserve conscience, and ensure laws do not become instruments of persecution anywhere, anytime, always.